Fighting conservatorship abuse is a complex and emotionally charged topic. Seeing a loved one ignored or taken advantage of by the person or persons charged with caring for them is extremely disappointing and difficult to process. In the following, we'll cover how to file a petition to suspend or remove an abusive conservator, and how to use litigation to secure a new conservator, fight a conservatorship, or terminate a conservatorship altogether. To fight conservatorship and conservator abuse, the first thing to do is consult a conservatorship attorney experienced in suspending, removing, stopping, and appointing new conservators. In many cases, like at RMO, the initial consultation is free. In many cases, a majority of the conservatorship attorney's fees and costs can be paid from the estate when your conservatorship dispute is won or settled. Of course, protecting your loved one remains the priority, but the reality is that the costs must be considered. The most popular reason to dispute a conservatorship is simple. The conservatee doesn't need to be conserved, or the conservatee no longer needs a conservator to make financial or life decisions for them. Example, their previous medical or mental condition has been resolved. In this case, the conservatee may file a petition to stop or terminate the conservatorship, as detailed below. Other common reasons to fight conservatorships are more complicated. The conservatee or their family feel that the conservator is not acting in the best interests of the loved one. In this case, they may want financial assets returned to the conservatee or other damages recouped. And lastly, we often speak to conservatees or their family members hoping to change the conservator to somebody the family prefers. In many cases, if it's in the best interest of the conservatee, the current conservator often will agree to this change with some simple discussions or negotiations. In other cases, it may require litigation. When an individual is no longer able to make financial or life, think health or medical, decisions for themselves, a conservator may be appointed to help them. A conservator will be appointed by the court at the request of a family member, friend, or the county. A conservatorship simply refers to the legal relationship between the conservator, who will be making the decisions, and the conservatee, the person who is unable to take care of themselves and is being conserved. Usually it's an elderly individual or somebody incapacitated by some sort of medical issue. Conservatorship abuse can take many forms, from physical abuse, like beatings, bed sores, broken bones, to emotional abuse, think verbal abuse and undue influence, or financial abuse. For example, financial affairs and disorder, unduly influenced gifts, theft of money, property, or real property even. Because financial decisions are most typically the responsibility of a conservator, the signs of conservatorship abuse tend to be financial in nature. Example, the conservator stealing or embezzling money from the conservatee. The signs of abuse tend to be the result of stolen money or missing assets. For example, unpaid bill notices that the conservatee receives at their residence for credit cards, cars, loans, taxes, etc. Another example is changes in family gifting, suddenly forgetting to buy birthday or holiday gifts, or giving gifts that are much smaller, less expensive than they had been in the past. A change in their normal processing. Another example is a change or changes in wills, estate plans, trusts. Is the conservatee suddenly taking back assets they'd promised to others in their will or trust because they suddenly need money, or they think they need money because they're being led to believe that? Another example is bounced checks. Is the conservatee or are their accounts suddenly bouncing checks where in the past they had been flush with cash? These are some of the basic signs of possible conservatorship abuse. If you suspect something, please call or email us for a free consultation. We're always happy to answer simple questions. Yes, a conservatorship can be contested in any state. Sometimes the simplest way to contest a conservatorship is to object to the petition for conservatorship to stop the conservatorship in the first place, or to file a competing petition for conservatorship. In either case, you'll want to engage litigation counsel familiar with litigating conservatorships and the specific issues that arise in these cases. If the conservatee is no longer incapacitated and able to make their own financial and life decisions, it's a relatively straightforward process to terminate the conservatorship. First, you should retain counsel who can help you prepare the petition to terminate conservatorship. Second, You'll submit the petition to the conservatee's county probate court where the conservatorship proceedings were proceeding. Third, receive notification of the hearing on your petition to terminate the conservatorship. Fourth, you attend the hearing with your counsel. Fifth, if the petition to terminate the conservatorship is not opposed or objected to, the court most likely will grant the petition and end the conservatorship, as long as you've demonstrated that the conservatee can handle their own affairs. If someone objects, whether it's the conservatee, conservator, or a family member, then you're going to have to litigate that issue, and you're going to have to convince the court that terminating the conservatorship is in their best interest. If you suspect your loved one is the victim of abuse by a conservatee, you will need to bring your concerns to the attention of the court. Typically, it's the children or family members of the conservatee who contest or dispute the actions of a conservator. Retaining counsel to help you investigate your concerns and present them to the court clearly will give you the best chance of convincing the court that the conservator needs to be suspended, removed, or even replaced. Conservatorship is similar to a power of attorney or guardianship in that it appoints someone to make legal, financial, or life decisions for another individual. However, the scenarios in which one person is appointed are quite different. Conservatorship is typically chosen when a mentally or physically incapacitated person is unable to make financial or life decisions for themselves. In such a case, a conservator is appointed by the court. Power of attorney is a common legal agreement in which a person of sound mind legally authorizes another person to make financial decisions for them. A person may give a trusted family member power of attorney to make financial decisions for them, such as buying and selling stocks or selling a home, renting a property. An advanced healthcare directive is another common legal agreement in which a person of sound mind legally authorizes another individual to make healthcare decisions for them. Guardianship is typically chosen when an underage person is legally unable to make financial or life decisions for themselves, including daily needs like grocery shopping, bills, paying rent. In such a case, a guardian is appointed by the court to make decisions and provide care. The cost of petitioning to stop a conservatorship is relatively affordable if uncontested, consisting only of the petition preparation, filing costs, and hearing attendance fees. The cost of contesting or disputing a conservatorship can be sizable and should be discussed in detail before a fight is undertaken. We recommend finding an experienced conservatorship litigation attorney familiar with the county probate court in the county where the conservatee lives. For example, if the conservatee lives in Los Angeles, we recommend working with a conservatorship lawyer in Los Angeles. A Los Angeles conservatorship lawyer will generally be more familiar with the Los Angeles Superior Court Probate Division versus an out-of-state attorney. At RMO, we protect people like you every day. Call or email us anytime.